Everyone, my name is Devendra Tiwari. I'm Associate Advocate at Law Chamber of SIDDHARTH MURARKA, and I'm back with another session of the Law Club webinar. I welcome all of you in today's session on behalf of Law Chamber of SIDDHARTH MURARKA and the Law Club. Today we have a speaker, Mr. Zal Andhyarujina, Senior Advocate, Bombay High Court, and he will be speaking on today's topic, enforcement and recognition of foreign award. Now I would like to request Zal sir to speak.
Good evening to all of you. Today's topic is the recognition and enforcement of foreign awards. It is a topic which has received a fair amount of judicial attention lately. There are some important judgments both of the Bombay High Court as well as the Supreme Court on this topic, which I will be discussing during the course of this discussion. I have invited two of my chamber colleagues also to be a part of this presentation. I have invited Mr. Kunal Dwarkadas and Mr. Karan Bhide, who are today also a part of this discussion. And I will request them to talk briefly also on some particular and detailed aspects of the matter. So Devendra, may I request you to just ensure that when I say that, both Kunal and Karan mics are put on and that they can actually...
Yes, sir. There is an option, sir. They can unmute themselves.
Okay, fine. Good.
Okay, sir.
So may I just check that Kunal and Karan, you're both...
Thanks, Zal. I'm here. I'm here, Zal. Thanks.
Hi, Karan. And Kunal, what about Kunal?
Hi, Zal. I'm here as well.
Okay.
Yes, sir. I'm on the call.
Okay, good. So everyone has been able to therefore identify my colleagues who will also be participating in this today. So having said all of that, since we are talking about the enforcement and recognition of foreign awards, I thought the first thing we should do was try to understand what exactly is a foreign award. So a foreign award is an award which is defined by the Arbitration Act. But broadly speaking, a foreign award is an award which is given by a tribunal in a foreign country, which is a signatory to either the New York Convention or the Geneva Convention. So, simply put, the award must be an award which must be passed by a tribunal which subscribes to, which is seated in a territory which subscribes to the New York or the Geneva Convention. Now, this obviously leads to the question about what these two conventions are. So there are two leading conventions which various countries have signed up to as a measure of reciprocity, so that awards which are passed by tribunals which are seated in those countries can be recognized in other countries. Sorry, Devendra, are you getting a lot of disturbance?
Yes, sir. I'll request everyone to please mute your mic. It is my humble request, sir. Otherwise, we will not be able to hear Zal, sir. Kindly bear with me.
I've also got a lot of chats which say that there's a lot of disturbance and people can't hear me. So let's press on. Let's see if we are able to deal with that. So this is what is a foreign award. And as I mentioned earlier, the two conventions which are important for the purposes of this discussion are the New York Convention and the second is the Geneva Convention. The obvious question is what these conventions actually do, in the sense that what do they facilitate? The conventions are treaties between the states whereby the states agree on a reciprocal basis that awards which are passed within the territory of other states will be recognized and enforced by the reciprocating states. So the earlier convention was called the Geneva Convention, and the later convention is called the New York Convention. So having spoken a little bit about what foreign awards are, we should also understand the distinction between foreign awards and other types of awards under the Arbitration Act. The type of award which probably most of us are most familiar with is the domestic award. The domestic award is an arbitration which has been conducted under Part 1 of our Arbitration Act, and it is an arbitration which involves two Indian parties. The difference between the foreign award and the domestic award is that the domestic award and the domestic arbitration from its very inception is governed by the Indian Arbitration Act. So the interim measures of relief, the appointment of the arbitrator, the conduct of the arbitration, the delivery of the award, and the challenge to that award in the context of domestic arbitrations all fall within Part 1. So quite simple. If both parties are Indian, it's an Indian-seated arbitration. It will be a domestic arbitration, and it will be entirely regulated and governed by Part 1 of the Arbitration Act. So that is the other end of the spectrum from what a foreign award is. Now, there is a third type of award, which is also important to understand. And this is an award which arises out of an arbitration, which is called an international commercial arbitration. So we're now talking about the third category of arbitration. An international commercial arbitration is defined by the Arbitration Act, and those of you who have it can see 2F. But the definition, broadly speaking, is that it must be an arbitration deciding disputes of a commercial nature, and one of the parties must be a non-Indian party. Broadly speaking, you can see the definition for yourself. I would not like to read the section, etc. to you. I think that will make it too technical and too boring for this type of discussion. But broadly speaking, that is what makes an international commercial arbitration. Now, the second part of our Arbitration Act, namely Part 2, it deals with the enforcement and recognition of foreign awards. So the early part of that arbitration, which results in the award, namely the appointment of the arbitrators, the conduct of the arbitration, right up to the stage where the award is delivered and the challenge is made to the award, are all governed by foreign provisions in the case of foreign awards. The interface with the Indian Act comes about only when that award is brought to India for the purpose of execution. And it is important to understand that there are three different processes involving foreign awards. There is a concept of recognition, there is a concept of enforcement, and lastly, there is a concept of execution. So the last few words that I've said are all to emphasize this important difference between the domestic awards and between the foreign awards. Namely, we are seeing foreign awards only at a stage at which the award is ready. Whereas we are seeing Indian or domestic arbitrations from their very outset, and we continue to then deal with their awards also under the Arbitration Act. So that's a big difference between these two types of awards. Now, let's just deal for a moment or try to understand for a moment whether every award in an international commercial arbitration will be considered to be a foreign award. Let's recall for a minute that an international commercial arbitration is an arbitration involving one non-domestic or non-Indian party and an arbitration which attempts to resolve disputes of a commercial nature. Now, this looks very much like a foreign award, but in fact, it is not a central case of a foreign award which is being dealt with by our Arbitration Act, because foreign awards as defined by our arbitration acts are awards which are passed only in countries which have subscribed to the Geneva and the New York Convention. So if you just take an example of an arbitration which took place between, let us say, an Indian party on the one hand, a Russian party on the other hand, and it took place in, just to give you an example, let us say in Mongolia or in Egypt, who are not signatories to either of these two conventions, then you will have a type of foreign award which is not being dealt by the Arbitration Act. And that award has been passed as a result of an international arbitration. So that's to illustrate the point that we can have certain types of awards which are not New York Convention and Geneva Convention awards, and therefore will not be considered as foreign awards under the Act for the purposes of enforcement and recognition and consequently execution. So what are we to do with such awards which arise out of international commercial arbitrations but are not what we call Geneva Convention and New York Convention awards? The current view, which is now clarified in the decision of BALCO, is that our Arbitration Act does not deal with such awards. This is something of a U-turn from another judgment called Bhatia, which took a different view. But the current position seems to be that. So just to summarize this segment of the opening part of it, we have three concepts we're dealing with. We have what we know as foreign awards under the Act, namely New York Convention and Geneva awards. We of course have domestic awards, which are then dealt with entirely by Part 1. And we have this third category of award, which is really a foreign award arising out of an international commercial arbitration, but it is neither New York Convention nor Geneva Convention, and therefore it is not dealt with the Act at all. The domestic award does not fall within Part 2 of the Arbitration Act. It is dealt with entirely by Part 1. The Geneva Convention and New York Convention orders fall squarely within Part 2 of the Act. And the third category, that foreign award from a non-treaty or a non-New York Convention, non-Geneva Convention seat or country, that is not dealt with by the Act at all. So we are hazarding a guess here, but if you get one such award, the remedy on that is probably the Indian or the party who wants to seek execution in Indian court probably has to resort to the general remedy by filing a suit on the award which it obtains in a non-convention country. So I hope this has been clear to you about what are the different types of awards, because now we'll go on to talk a little bit about the actual process of enforcement and execution of convention country award, namely New York Convention Award and Geneva Convention Award. Now, before that, I had mentioned these two cases, BALCO and Bhatia, and I'm going to request my colleague Karan just to talk to you for about 2 to 3 minutes on what the position was under the Bhatia judgment and how the position changed with BALCO. So Karan, can I request you to talk to our audience on this for about 3 to 4 minutes or whatever time you think about.
Sure, sir. Thank you. And thank you to the Law Club for organizing this event. To start with, I'm just going to trace back to what Zal already said, that a foreign award for the purposes of Part 2 of our 96 Act is necessarily a convention award. Now, why this is relevant is something I'll come to, but what happened in Bhatia International was very interesting. Actually, so Bhatia International came out in the year 2002. The citation for those of you all who want it is 2002 for SCC 105. Bhatia International was a 3-judge bench, and the judgment was authored by Justice Varyava. So much prior to Bhatia, we actually had a division bench of judgment of our court, which categorically held that Part 1 was always excluded for foreign seated arbitrations. What happened in Bhatia was there was a Section 9 filed in arbitration agreement where the rules of ICC were made applicable. The petition was met with a test of maintainability because Bhatia argued before the district court there to say that Part 1 was always excluded in a foreign seated arbitration. That was decided against Bhatia, and it was carried in writ appeal before the before the High Court, which eventually came up before the Supreme Court. Now, the Supreme Court reasoned this with several reasons, but the ones that are relevant for us today are really these. That number one, the Supreme Court said in international commercial arbitrations, which are held outside India, a party would always be left remediless insofar as it couldn't procure a relief under Section 9. But what is more relevant for us today is that it said that there cannot be perceived to be a legislative lacuna on in the Arbitration Act insofar as non-convention awards were concerned. So Justice Varyava really said that non-convention awards could not be completely excluded by the Act, and that could not have been the intention of the legislature. So what he did there was he relied on Section 2, subsection 7, and harmoniously construed that with subsection 2 and subsection 4 and 5 of Section 2 to hold that Part 1 is always applicable, whether the seat of the arbitration is in India or outside. Now, this position continued for about 10 years until BALCO came out. But much before BALCO came out, actually in 2008, was the decision in Venture Global of the Supreme Court. The citation there is 2008 for SCC 190. In Venture Global, what happened was they really only reaffirmed or sort of applied the principle already propounded by a 3-judge bench in Bhatia International. Then we come to 2010, which is when BALCO came out. Now, BALCO came out, as if you all see para 1, was on account of the differences in opinion among the various high courts, construed together with the judgment in Bhatia International and Venture Global. Now, BALCO is a judgment on several issues, of which I'm not going to bore you today, but insofar as what is concerned for our talk today, what it held on non-convention awards was this, and it is summarized in para 169 of the BALCO judgment. It says that merely because such non-convention awards were excluded, it does not mean that there is a lacuna. It only means that such awards are not recognized and are not enforceable. Number two, it traced us back to the prior legislation, namely the Arbitration Act 1940, which was the Domestic Act. Then you had your Arbitration Protocol and Convention Act of 1937, which was the Geneva Convention Act. And then came in the New York Convention in 58, which resulted in the Foreign Awards Recognition and Enforcement Act of 61. And therefore, the Supreme Court said that even under the prior scheme of this arbitration law in India, we never recognize non-convention awards. And it is not as if they're recognized today by the 96 Act. More importantly, the Supreme Court stressed that even after consolidating all of these legislations into the 96 Act, the Supreme Court has evaded the opportunity to curb this lacuna and have some law on this. And therefore, it really left it at the fact that non-convention awards as such are not recognized by Indian courts and as such are unenforceable. But why all of this is relevant on a separate note is because of the 2015 amendment. And the 2015 amendment, in my view, really took us back to Bhatia. Although I must say that Bhatia should have limited his judgment on the Section 9 relief and not applied it to the whole of Part 1, which it did. But what the 2015 Amendment Act, as will be discussed by Zal and by Kunal, does is that it really brings in your Section 9 and 27 and 37 remedies, even in respect of arbitration, international commercial arbitration seated outside India. So really it comes back to the Bhatia principle, and BALCO of course was passed at a time when the 2015 Amendment Act did not exist and the proviso to 2.2 did not exist. So it was in that background that these judgments were construed.
Thank you for that, Karan. Karan, just one issue perhaps I'd like you to talk about before you leave.
Sure, sir.
What was the necessity in Bhatia's judgment for the Supreme Court to discuss the applicability of non-convention awards under the Act? Can you tell our audience why it was necessary, if at all, for the Supreme Court?
Absolutely. In fact, Sal, this is the most interesting point about the judgment. As I mentioned, it was a Section 9 case before the Supreme Court, and Supreme Court could have limited its view only on Section 9, as is done by the 2015 Amendment Act, in fact. But what the Supreme Court did was it traveled beyond that scope and construed the whole of Part 1. And this, in fact, was not warranted in terms of any of the submissions made before the court either. But this was something that the court came up with in para 14 to say, listen, what happens in these cases? It can't be that these cases are completely left, sort of not recognized at all. And that is where I believe Justice Variava sort of tried to curb or sort of supply the omissions of the legislature in that manner. But it was really not something that was up for the Supreme Court in terms of what it was required to do in the judgment, if that answers your question.
Okay, thank you, Karan. So if I can just summarize and make one or two points on what Karan has already said. I think the weight of scholarly as well as judicial opinion now seems to be that actually Bhatia was a decision which was not on the same wavelength as many, many subsequent and contemporaneous decisions. In one sense, Bhatia has been viewed as being not correctly decided. And I think Balco, which ironed out a lot of creases which had taken place in the Arbitration Act, took the opportunity to actually clarify that as well.
Yes.
So perhaps if you want to fit in Bhatia properly with Balco, the real reason is that the judges, while deciding Balco, did think that Bhatia didn't quite get it right.
Absolutely.
The Balco.
Absolutely, absolutely.
So thank you for that, Karan. I just want to once again reiterate 2 or 3 interesting dates for you. Karan did mention them, but Karan, as usual, speaks at express speed. So I'll just say them again slowly for you. In 1937, we had the Geneva Convention, which then came to be recognized by an Indian statute. You're all aware of the fact that treaties must be actually incorporated into Indian law. So the very fact that you sign a treaty is not sufficient to bring it into effect in Indian law. So we had an act which has a long name, but effectively it was called the Protocol Act. And the Protocol Act brought the Geneva Convention into Indian law. So the Geneva Convention was the first of the conventions. About 20 years later, 1958, comes the New York Convention. And the New York Convention was then brought into Indian law by a 1961 statute, which is called the Foreign Award Recognition Act, so on and so forth. So these 2 conventions were brought into Indian law by these 2 statutes. And the 1996 Act then consolidated these 2 conventions as a part of Indian law, as I will be demonstrating to you a little later in the talk in part 2. So that just summarizes the first segment of what I wanted to set out. The 3 types of awards, the controversy which was there with regard to non-convention foreign awards arising out of international commercial arbitrations, and how they contrast with the domestic award. Now, having explained all of that and given you a little bit of background with regard to how these 2 important conventions also came to be a part of our law, we'll just now go and try to understand the process of enforcement and execution. So that is the second part of what I want to talk to you about, the actual process. Now, those of you who are familiar with the Act will know that part 2 of our Act deals with the enforcement and execution of foreign awards. Sorry, I'm just going to wait for that to go away. Okay, are we happy? Okay, okay, it seems to have died down, so we can talk a little more now. Okay, so part 2 of the Arbitration Act, it is dealing with the enforcement and execution of awards. Now, part 2, if you see the act itself, and I have the act here, so I'm going to just read to you how part 2 starts, because that's quite interesting actually, and very revealing about what it says. The title to part 2 is Enforcement of Certain Foreign Awards. So it is only talking about certain type of foreign awards, namely the New York Convention and the Geneva Convention awards. And the point that I made to you earlier about how part 2 deals with only the arbitration from the award stage is also a point which is made in Balco's case. And it makes it very well to say that actually when you're dealing with foreign awards, you're only dealing with the end part of the arbitration. When you're dealing with domestic awards, you're dealing with the entire part of the arbitration. So that is how it starts, and the title itself tells us exactly why these two conventions are important. The New York Convention is then dealt with by section 44 of the Arbitration Act. And I don't like to read much to you, but I'm just going to read this to you carefully so that you can understand what exactly is the New York Convention. Now, the definition of a New York Convention award is set out in these terms. In this chapter, unless the context otherwise requires, foreign award means an arbitral award on differences between persons arising out of legal relationships, whether contractual or not, considered as commercial under the law in force in India, made on or after a particular date. And there are two cumulative conditions: in pursuance of an agreement in writing for arbitration, to which the convention set forth in the first schedule applies, and in one of such territories as the central government being satisfied that reciprocal provisions have been made by notification in the official gazette declare to be territories to which the convention applies. So, part 2 in chapter 1 defines what is a New York Convention award. Now, there is a similar definition in section 53, and that deals with a Geneva Convention award. I'm not going to read it. It's more or less the same, except it has the relevant change from New York Convention to Geneva Convention. So the statute clearly sets out the two types of foreign awards we are dealing with, namely the New York Convention and the Geneva Convention. Now, for those of you who are interested, the first schedule to the Arbitration Act actually sets out the New York Convention, and the second schedule to the Arbitration Act sets out the Geneva Convention. So you can see the slight differences also that are there between the New York Convention and the Geneva Convention. It's a matter of great detail and too much detail to go into in a discussion such as this. But for those of you who are interested, you can contrast the first schedule to the second schedule to see the differences between the New York Convention and the Geneva Convention awards. Now, that takes us to actually the mechanics of how this works. So, how does the enforcement mechanism actually work? The enforcement mechanism requires the party who seeks enforcement to file a petition under Part 2. Now, if you have a New York Convention award, then you will come under Chapter 1 of Part 2. If you have a Geneva Convention award, you will go under Chapter 2 of Part 2. So let's take a case now that we have a New York Convention award. You have to file a petition in, let us say, the Bombay High Court, which could be the court which is defined for the purposes of Part 2. And you would file that petition to enforce the award. And you would say in that petition that this is the award that I have obtained and that it should be enforced so that it can be executed. Now, why is it important for a party to seek enforcement? Now, the law on this is now well settled that a foreign award which is passed abroad but not enforced is not valid and binding in India. So if you have a foreign award which is passed against, let us say, an Indian party, and the foreigner seeks to get some relief based on that award, say he tells the Indian party that you must pay him, the Indian party could well say that as far as Indian law is concerned, your award is not in any way valid and cannot be acted upon till such time as you come for enforcement. So that is the important part of enforcement, that the process of enforcement makes the award a valid award under Indian law, and the party who seeks to then rely upon that award can rely upon that award, which he can't do otherwise. So coming back to our illustration, the party who succeeds and wants enforcement will now file a petition in an appropriate court in India. Now, I want to once again just indicate to you some of the relevant provisions of the Act which deal with this exercise of enforcement. So, the first part of the enforcement mechanism, as it were, it starts with section 47 and 48 of part 2. Now, I'm going to read you some relevant parts of 46, 47, and 48 to indicate what exactly it involves. So section 47 reads thus: the party applying for the enforcement of the foreign award shall at the time of the application produce before the court the original award or a copy thereof duly authenticated in a manner required by the law of the country in which it was made. B, the original agreement for arbitration or duly certified copy, and such evidence as may be necessary to prove that the award is a foreign award. So that tells us about the type of evidence you require. It's not a great deal. It is the original award or a certified copy of the award. It is the original arbitration agreement and such evidence to prove that it is a foreign award, such that it was passed abroad in a foreign seated arbitration and that the convention applies to it. So that is the initial threshold which a party has to cross. Now, having done that, we then go to 48. Now, 48 sets out the conditions which are required for enforcement of the award. And you will see that, in fact, it is couched in the negative. In the sense, it says that the award will be enforced unless X, Y, Z. Now, I'm going to read some parts. It's a very long section, so I'm going to read some parts of 48 to you to give you an indication of how it works. So 48, the title says this: conditions for enforcement of foreign awards. 1. Enforcement of a foreign award may be refused at the request of a party against whom it is invoked only if that party furnishes to the court proof that. So the general position, the starting position, is that the award will be enforced unless these negative conditions are proved by the opposing party. Now let's have a look at some of these negative conditions. In subparagraph A or subclause A, the first is the incapacity defense. And I'm going to read that to you. So you will be able to resist enforcement if the parties to the arbitration referred to in section 44 were under the law applicable to them under some incapacity, or the agreement was not valid under the law to which the parties have subjected it, failing any indication thereof under the law of the country where the award was made. So if one of the parties had an incapacity, say that there was a force majeure event which prevented him from attending the arbitration, or say that the arbitration agreement was invalid for some reason of foreign law, which was the applicable law, that would be a good defense. So that's A. B, that the party against whom the award is invoked was not given proper notice of the appointment of the arbitrator or the arbitral proceedings, or otherwise unable to present his case. It more or less speaks for itself, that there was some procedural lapse in the proceedings. C, that the dispute which is decided was not a dispute which was actually contemplated or falling within the terms of the submission of arbitration. So the parties decided to go to arbitration to decide issue A. The arbitrator, however, decided issue Z or issue X, Y, and Z. These are not matters which were referred to arbitration. That also is a ground for resisting the foreign award. And D is that the composition of the arbitral tribunal or the arbitral procedure was not in accordance with the agreement of the parties. So you have a little flavor of the types of defenses which can be raised successfully to resist the enforcement of a foreign award. Now, many of these defenses are difficult to establish because normally foreign seated arbitrations are careful in their procedure. The incapacity defense is a very rare defense in my view, in my experience, to have succeeded. Normally parties are fully capable and do attend and are perfectly enabled to participate in the arbitration proceedings. It may be possible that a party may successfully raise a defense to say that the arbitration agreement was invalid under the foreign law, but it is once again very difficult in an Indian court. You have to first of all say what the foreign law was, you have to establish the foreign law, then establish why it was actually invalid under the foreign law. So all an uphill task. Now, frequently, therefore, we see that opposition to awards are now being made on what follows. And what follows is this. And this is subsection 2 to section 48. Enforcement of an arbitration award, arbitral award, may also be used if the court finds that the subject matter of the defense is not capable of settlement by arbitration under the law of India. So, for instance, let us assume that the law of country X allows in rem rights to be decided in arbitration, which, as we all know, under our Booz Allen cannot be done in India. Then it is possible that your challenge to the enforcement may succeed. So the first commonly used ground is this, that the subject matter of the difference was not capable of settlement by arbitration in India. Now the second is a very, very important ground, and there's a lot of case law on that we'll come to shortly. But the second is this, that the enforcement of the award will be contrary to the public policy of India. So this is the public policy defense on which the courts have had to say a great deal in the not so recent past. I'll just take you to that briefly though. But I'll read this section on to you because it is an important explanation. Now, this explanation reads thus, that for the avoidance of doubt, it is clarified that an award is in conflict with the public policy of India if the making of the award
Zal sir, can you hear me?
Zal, you may be muted.
Yes, sir. Sorry.
Sorry, Devendra. Am I back on again?
You're back.
Yes.
Okay. Sorry. What did I go on very long? Did I talk?
No. By mistake, sir, I had muted you because there was so much noise. So I just pressed mute all, so
So
you
just
also muted.
to briefly recap, and I must also maintain my time limit, so I'll go a little quickly here. The important defense, which is frequently used in our Indian courts, is the public policy defense. The public policy defense is set out in section 2 of section 48. And I'll read it again just in case some of you missed it. What it says is this, that the enforcement of the award would be contrary to public policy of India is a ground for resisting the award. And there is an important explanation there which sets out what exactly is the public policy defense. So the public policy defense is what I'm going to briefly talk about going ahead now. And my colleague Kunal will also assist us in understanding one or two cases which are important with regard to the public policy defense. Now, I'm going to address the issue broadly first. Many of you must be familiar with the concept of public policy. And public policy has generally a wider dimension and a narrower dimension. The question that has arisen before courts considering challenges to the enforcement of foreign awards has generally been about what is the threshold for the test of public policy. Should we make the public policy defense broad or should we make it narrow? Obviously, if you have a very broad defense, it is entirely possible then that many challenges will succeed. If you have a narrower defense, then it will be more difficult for challenges to succeed, and a great deal of challenges ought to actually fail. And only if the heightened test of public policy is met, will they succeed. Now, we started out with a leading judgment in the case of Renu Sagar. And Renu Sagar's case set out a fairly narrow view of public policy. From Renu Sagar, we have now come full circle, running through several cases which sought to widen the public policy angle. And we have once again come to a narrow definition of public policy. And in this, there has been a recent amendment in 2015 to the Act as well. And the 2015 amendment has discarded a wider notion of public policy, and it has focused on a much narrower notion of public policy. Now, there is a long list of authorities. It starts with Renu Sagar, it goes through ONGC, it goes through judgments such as Lal Mahal, Western Gecko, so on and so forth. But that is a very detailed analysis which we can't do during the course of this discussion. I have therefore requested my colleague Kunal just to talk briefly about the latest judgment of Justice Nariman in the Vijay Karya case, and that will summarize the position as on today. Justice Nariman says that we must view the public policy defense under 48 as being, in his language, watertight, in the sense that it is to be regarded as a narrow defense in the context of foreign awards, and it must not be colored by more generous notions of public policy, which are available under Section 34 and elsewhere in the law. So with that little introduction, Kunal, can you tell us a little bit about the Karya judgment and how the Karya judgment has brought about a change in the law which was there previous to the Karya judgment, and in one circle brought us full circle back from Renu Sagar. But Kunal, you'll have to do it within 5 minutes or so.
Okay. Sure, Zal. Yes. Firstly, thank you, Zal, for sharing your platform with us. Good evening, everyone. As Zal said, there is a very recent judgment of the Supreme Court authored by Justice Rohinton Nariman of February of this year in the case of Vijay Karya versus Prismian Kavi, which really, in my view, is the seminal judgment on challenges or applications to resist the enforcement of a foreign award. particularly on the ground of the public policy doctrine. But before I get into the Vijay Karya judgment, just one other judgment which I would like to point out and flag for everyone's attention is the judgment again authored by Justice Nariman not long ago in May of last year in Sanyong versus the National Highway Authority. And the reason I bring that judgment up is because that's really the first judgment that's come out of the Supreme Court after the 2015 amendment to the Arbitration Act, which has explained in detail, and I won't go into it, but it has explained in detail and really traced the history of the law, as Zal was saying, beginning from Renu Sagar through ONGC saw pipes on this aspect of the public policy doctrine. And I would urge all of you, in case you haven't read it, to please read it. 2 or 3 things I would like to say about that judgment on the public policy aspect are, firstly, do bear in mind that Sanyong's case was a section, it arose out of a domestic award in what were originally section 34 proceedings, then in section 37 appeal, which traveled all the way to the Supreme Court. However, in view of the 2015 amendment to the Arbitration Act, and in particular, the amendment to section 34 and 48, which really defines what is public policy of India. And when you read it, you will see that the definition under section 34, which is a challenge to a domestic award, is identical to the definition of public policy under section 48, which deals with foreign awards. So in Sanyong's case, Justice Nariman has set out in great detail what, after the 2015 amendments, is, according to him, the correct interpretation of the public policy doctrine. And to summarize it, he really says that there are 3 heads that would fall under public policy, and that's apparent from the statute. He says it would be a contravention of the public policy of India if an award were to violate fundamental policy of Indian law. You can note down that fundamental policy of Indian law, he says, has been explained by himself in an earlier judgment of his in Associate Builders versus Delhi Development Authority in paragraphs 18 and 27 of that. The second head is if the award was induced, or the making of the award was induced by fraud or corruption. That's self-explanatory. And the third head is if the award is in conflict with basic notions of justice or morality. And once again, in Sanyong, he says that he has explained what is the meaning of basic notions of justice and morality in paras 36 to 39 of Associate Builders case. The only other thing that I would like to say about the Sanyong judgment is, when you do read it, it really clarifies for us that the various judgments, ONGC saw pipes, ONGC versus Western Gecko, and the Supreme Court's real expansion of the meaning of the term public policy is not to be now accepted in a public policy challenge to an award, whether domestic or foreign. It is to be the narrower view, the view that was originally taken in Renu Sagar, which is what the courts are now to follow. Having said that, I come now to the Vijay Karya versus Prismian Cavi judgment. As I said, it was decided in February of this year. The reason it's most important to today's topic is because it is a foreign award case. There was a London-seated LCIA rules arbitration that was held. The governing law was English law. The appellants, that is Vijay Karya and others, were all shareholders in a company named Ravin Cables Limited. And the appellants as shareholders, along with Ravin Cables, the company, had entered into a joint venture agreement with respondent number 1, Prismian, which is an Italian company. And under that joint venture agreement, Prismian had acquired 51% shares of Ravin. The usual clauses were to be found in that joint venture agreement. What is of importance to us today is that there was an event of default clause, and the failure to cure that default resulted in the non-defaulting party having an option either to purchase the defaulting party's shares at a price which is 10% lesser than the fair market value, or the option to sell his shares or its shares to the defaulting party at a 10% premium to the fair market value. And when I say that, I can tell immediately that there is an issue there with in relation to the Foreign Exchange Management Act that would creep up, and sure enough, that was a part of the discussion. But the other relevant background before I come to the public policy discussion is the award went in favor of Prysmian, that is the Italian company, and the appellants, the Indian promoters, and they were directed to sell their shares to Prysmian at a 10% discount to fair market value. Now, the appellants, that's Vijay Karya and the other promoters, did not challenge this award in England. And Prysmian brought this award to India for its enforcement. Obviously, at that time, Vijay Karya and the other promoters resisted the enforcement, and at that is when Section 48 and the grounds under Section 48 kick in. Now, the Bombay High Court originally held that the awards were enforceable under Indian law. An interesting point for everyone to note is that if an award is held, if a foreign award is held to be enforceable by a high court, there is no appeal provided under the Arbitration Act. And therefore, you have to go directly to the Supreme Court by way of an SLP. And the reason for that really is because India encourage arbitration, and it wants to ensure that foreign awards particularly can be enforced and the fruits of those awards can be enjoyed by an award holder rather than going through this longer process of an intra-court appeal, etc. The Supreme Court, of course, when deciding this matter, Justice Nariman in paragraph 24 immediately sounds a note of caution, and he says, look, just because you have a right to come to the Supreme Court does not mean that the Supreme Court is going to interfere. And he sort of lays down this broad test to say that it is only a blatant disregard of Section 48 by the High Court that would really find favor with the Supreme Court when it comes to resisting enforcement. Now, some of the arguments really I'll touch upon that were made before the Supreme Court were that the arbitral tribunal failed to deal with a counterclaim in its entirety, that material evidence had been ignored, that admissions and evidence had been ignored, and lastly, that the arbitral tribunal's interpretation of the contract was perverse. Now, I'll deal with each of these as Justice Nariman has in his findings. But what I want to first point out is Renu Sagar, which was the judgment of the Supreme Court in 1994, has been relied on. We have in that sense come full circle, and Justice Nariman says Renu Sagar continues to hold the field in view of the 2015 amendments to the Arbitration Act. He also refers to Shrilal Mahal, the judgment in Shrilal Mahal, to say that, look, it's always been a position in India that foreign awards are not tested in the same manner as domestic awards are, and you have to take a narrower view of the public policy ground. As Zal said, in para 46 of the judgment, Justice Nariman has said that the grounds under Section 48 are watertight, and no ground outside of Section 48 can be looked at by a court. Now, one interesting argument that was made before the Supreme Court was which of Section 48 is that a court may refuse to enforce a foreign award. And so the appellant took an argument made an argument to say that, look, the word may shows that there is this discretion that is available with courts, and therefore you really can't say that 48 is watertight. There is some element of discretion involved. And Justice Nariman, what he has done is he has taken Section 48 and the various grounds which Zal read out earlier, and he's divided them into three broad categories. He says there are grounds. First is there are grounds which affect the jurisdiction of the arbitration proceeding itself. For example, the arbitration agreement was not valid under the governing law, or the subject matter of that dispute was not capable of arbitration. And he says that these grounds, there is no discretion, that award will not be enforced. The second broad category are grounds which affect party interest alone. For example, a party was unable to present its case. Now, these are typically grounds that can be waived or can be abandoned, or grounds that may not actually cause prejudice to the party. So Justice Nariman says, well, look, those grounds seem to be, yes, the court can exercise some discretion, and you may very well choose not to enforce such an award. It would, of course, be depending on the facts of each case. But he does once again sound a word of caution to say that, look, courts should ensure that these grounds really should go to the root of the matter. It should amount to a denial of justice, not merely some procedural flaws in the conduct of the arbitration which don't result in a denial of natural justice. And then the third broad category under Section 48 is the public policy ground, which he says there is no discretion. Now, on the aspect of public policy, I think what's important to note is that in this case, the argument was couched to say that, look, the clause provided for a purchase or a sale of shares at 10% higher or lower than fair market value, and that this contravenes the FEMA regulations which say that, look, foreigners can buy and sell shares only at fair market, of Indian companies only at fair market value. So obviously the argument taken was that, look, this award directing me to sell my shares at a 10% discount violates FEMA. Justice Nariman in paragraphs 79 to 84 and in paragraph 105 has said that FEMA, unlike the earlier statute, which was the FERA, the Foreign Exchange Regulation Act, really it only manages and does not police foreign exchange. And under FEMA, transactions that violate FEMA are no longer void as they were under FERA. And in fact, breaches of FEMA are rectifiable. In many cases, you can even take ex post facto permission from the RBI. So considering these three factors, Justice Nariman comes to the conclusion that FEMA is not part, or the statute is not, a violation of FEMA would not amount to a violation of the fundamental policy of Indian law. And I think that is extremely important, because what it tells us is today, under the amended provisions of the Arbitration Act, there are two principles that we must bear in mind. And you will find these in Sanyong. A mere contravention of substantive law like FEMA is no longer a ground to set aside an arbitral award. And this also means that a contravention of a statute that itself is not linked to public policy or public interest cannot be brought in by a backdoor challenge, by bringing it under a fundamental policy challenge, because what the Supreme Court has said is that is actually a patent illegality challenge, and patent illegality is not a ground that is available to resist enforcement of foreign awards. So to conclude, I think anybody who has to deal with a case relating to a foreign award, whether you are seeking enforcement or you are seeking to resist enforcement, I urge you, if you haven't already read, please do read Sanyong, and please do read the Vijay Karya judgment. They are very helpful, and they really now settle the law on what is the meaning of public policy under sections 34 and 48.
Okay, thank you very much, Kunal. So Kunal has given us a very full description of the public policy defense. I'd just like to underscore one or two important points which he made, something that we should definitely take home from his description of the judgments. The first is that the general policy of our courts has been, in my view rightly, to considerably tighten the public policy exception of the defense. The second is that, in fact, statute has also stepped in the form that we have an amendment which was made to the relevant provision, which effectively swept aside the judgments which suggested that a wider approach should have been taken. And thirdly, the Supreme Court, as well as the statute, has now said that it has to be a fundamental breach of public policy. Now, that is very important. It's not just any old ground of public policy. So it has added the word fundamental, which gives you an idea about the threshold which has to be scaled to actually succeed in the public policy defense. So as Kunal rightly said, the Vijay Karya decision today is the leading authority on this point. It summarizes a great deal of law, and anyone who's interested in the details of this defense should go ahead and read that judgment. Okay, thank you very much, Kunal. Thank you for that. So we've spoken a little bit now about the enforcement mechanism. We've spoken a little bit about how a party will seek to enforce. We've spoken a little bit about the types of defenses that could be raised, and we've spoken a little bit about the public policy defense. One or two incidental matters that you may or may not want to know is no stamping is required when you bring a foreign award to India. And the second is that you don't have to immediately bring the actual physical award. There are two judgments on this, both of which clearly specify what I have said. Once you get enforcement, you are ready for the next important step, namely execution. So once your award has effectively been enforced, you can then dip into the process of execution. And execution, like all execution in our country, it follows the procedure under the CPC for execution of the award. So the actual collection once again resorts to the procedure under the CPC. So that concludes the second segment of what I wanted to discuss with you with regard to enforcement and execution. And that takes us, I'm afraid we are running out of time. So I'm going to be a little brief on this last part. I'm going to just summarize it in about 2 to 3 minutes. It's a very important aspect of the matter. And the issue is whether you can apply for relief under Part 1, Section 9, when you come for enforcement of foreign awards. So there was a great deal of controversy on this issue, but Bombay High Court has in fact now settled the point, and it has clearly held in a leading judgment called the judgment of Heligo helicopters that in fact Section 9 is available to all parties who also seek enforcement of foreign awards in India. My opinion is that that is a move in the correct direction because it frequently happens that even enforcement actions in India take a long time. And in the meantime, the assets which are in India can either be diverted or they can be removed, can be moved elsewhere. This is important because the law with regard to the court that you choose for enforcement and consequently execution says that the assets should be within the jurisdiction of that court. So there is no point in you bringing your enforcement action if by the time your enforcement action is heard, all the assets are diverted to another jurisdiction. And therefore, quite sensibly, the High Court has ruled in Heligo, which was a single judge's decision, which then was affirmed by the division bench, and now in other judgments also, that this type of Section 9 relief is indeed possible. Since Kunal is also on the call, Kunal and I recently appeared in an enforcement action where there was a Section 9. An unusual sort of occurrence took place there, that with the introduction of the 2019 amendment to the Arbitration Act, the earlier amendments of 2015 were not available for arbitrations which commenced prior to 2015. And that made a very significant difference because it removed a part of the section which was otherwise available to found a Section 9 relief. Just to make that clear, one part of the Arbitration Act actually says that international commercial arbitrations can avail of Section 9 relief. That came in through the 2015 amendment that came to be rendered ineffective for arbitrations prior to 2015 by the 2019 amendment. So we found ourselves in court, and our opponents raised this point to say that with the 2019 amendment, Section 9 relief is no longer possible. The learned single judge, Justice Kulkarni, quite rightly held in their favor and dismissed our petition. Fortunately, a few months later, the 2019 amendment itself came to be set aside by Justice Nariman in the HCC judgment, and therefore the position once again reverted to the fact that Section 9 relief is maintainable in foreign awards. And in fact, coincidentally, that very matter where we were applying for relief under Section 9 was today before Justice Sriram for ad interim relief. Unfortunately, because of some difficulties with the video conferencing facility, we couldn't have an effective hearing, and the matter is now to be heard on Monday. So we'll see what happens there as well. I'm afraid we've spoken for perhaps a little too long. So with that, I will conclude this discussion. I want to thank both Karan and Kunal for their very clear presentations on those two aspects of the discussion. So Devendra, over to you. And,
yes, thank you, sir. Anyone has any questions to ask? I think, sir, there are a few questions in message box.
Okay.
I can see one, sir, that will an award through an ICC arbitration seated in India be a domestic award or foreign award?
Sorry, I'm just reading it. I can see it. Can you repeat that question again, please?
Will an award through an ICC arbitration seated in India be a domestic award or a foreign award?
It's an Indian seated award, right?
Yes, yes.
So it depends on who are the parties to the award. If one of the parties to the award, for example, is a foreign party, it will then become an international commercial arbitration. So if you have, for example, if you have, it is normal, in ordinary course, it would be a domestic award.
Okay. There is one more question, sir. Can we file a Section 9 in case of an international commercial arbitration in Bombay High Court, even if the Indian party does not have any assets in India?
Well, the prerequisite for filing your enforcement action would be that the court in which you file is the court in which the party has assets. So I think the answer to that would be no, because Section 9 is an interim application in the final petition being the enforcement action. So you would have to have assets to actually file the Section 9.
Okay, so one more is there. A limitation for enforcement of foreign award is as per foreign law or Indian law?
Well, the judgment is Justice Deshmukh's judgment in the context, I think it's called Noi Valasina, which sets out that the Indian Limitation Act will apply, and the period of limitation is 3 years from the date on which the award was made. You have to bring your enforcement action within that period. And then as usual for execution, I think you have 12 years.
Okay, so there was another question, sir, that what is the limitation to enforce a foreign award?
That's the answer to that. It is
3 years.
3 years from the date on which the award was made.
How to enforce foreign awards passed without both convention?
Well, that is what I touched on in the opening part in the first segment, that it may be difficult to enforce them. You may have to file a suit on them. You may then have to actually have the whole suit heard on that.
Okay, okay. So, sir, I would like to thank you for enlightening us on today's topic. I would like to also thank your junior and assistant, Mr. Kunal and Karan, I think. And this session was really very informative. And I'm sure that it will surely help to all newcomers like me and many participants, students who have participated in today's session, sir. And we are looking forward to have many more sessions by you in future, sir.
Thank you, Devendra, and thank you all for participating and for staying so long on the talk and listening to this. Thank you.